law reform process is the way that we as a society go about solving legal problems. And we do that by breaking those bigger problems down into smaller problems, and by consulting the community and getting key stakeholders involved in creating solutions to those problems. Now, this is a process that's come out of custom. It's developed out of practice. There's no rules that are ever laid down as to this is the way it should be done. It's simply the most efficient way that we've found to do it. And it's part of, and connected, I think, with the idea of deliberative democracy. That is, that democracy works best when it's done in a rational, formal way, with time to think, time to consult, and time to weigh up options. This is opposed to the rather wrong idea of conflation of democracy with mob rule, where everyone wants something done and suddenly there's public pressure or an angry mob wanting things changed. Deliberative democracy is much more formal, and I think the idea is to try and avoid poor choices where the public are swayed by changes in public opinion, particularly when that opinion is manufactured by media interests. And today this has become incredibly important to us to actually find that sort of middle balance. Now, the origins of law reform comes in commissions of inquiry, or royal commissions. Those words are fairly interchangeable. And many of our law reform bodies are established as standing commissions. So, if you forgive me, there's probably a need for a quick detour into what a commission of inquiry is. Now, this is a very big topic, and I could do several more videos on this, but I'll try and keep it as brief as possible. And it's important to understand the separation of powers to start with, because commissions of inquiry come under the administrative head of power, and that will become important later on. And they are the modern manifestation of the power the monarch used to have to commission individuals to go and complete particular tasks. So back in the old days, the king would find the sewages backing up in the moat, or there's witchcraft out in the villages, and they would commission someone, a trusted advisor, and say, "Go here are the powers of the king, go out and find out what's going on and report back to me." And this is why commissions of inquiry only have reporting and recommendation powers. They can't determine anything. It's quite distinct from the judicial forms of power, where they can actually form resolutions, make decisions, and affect people's rights. So it's part of the Crown power, and of course today that power is manifested in government, and particularly the Attorney General as the head of the legal part of the government. Now, in Australia, those common law rules have been codified, and we have legislation at state level, commissions which create commissions of inquiry, and at the federal level that create royal commissions. Now, they're fundamentally the same thing. The main difference in terminology is a royal commission is Commonwealth, and a commission of inquiry is a state body. These commissions, these inquiries, have limited lifespan, and one of the different variations we have are standing commissions, which can live technically forever until the legislation is revoked, and they require their own specific legislation. They're not set up under the generic powers. They are created under their own legislation, and this is typically what happens with anti-corruption bodies, and it also happens with law reform commissions. They will often have their own legislation that sets them up and gives them power. There have been lots of different inquiries in Australia. The most famous, of course, would probably be the Fitzgerald Inquiry into public corruption that occurred in Queensland, and I think it's a good example of some of the pros and cons of our particular approach to inquiries. In Australia, we have a rather unusual approach in that we often have inquiries headed by a judge, and they run in a process that very much resembles a courtroom process, very formal, with witnesses giving evidence and so on. And I think that has its origins in our history as a colonial nation, and the fact that many years ago the Australian colonies were so far away from the British Crown that they felt as though we needed this kind of added layer of formality. But of course this does create confusion, and I remember after the conclusion of the Fitzgerald Inquiry, when recommendations were passed up to Parliament, people said, well, why aren't these people being convicted? They've gone to court. Why? They've sat before a judge, they've admitted corruption. Why haven't they been convicted? And that's because of the format that we use. And that's a problem. I mean, one of the reasons why, and one of the key reasons why commissions of inquiry don't have power to make determination is they have very, very strong inquisitorial powers. In particular, they can usually override the privilege against self-incrimination. So you can see there's going to be a real problem. If you can force someone to speak, you can negate their privilege against self-incrimination, and then later on you can then prosecute them on the basis of the evidence they gave. That's a real problem. So what do we do about it? Well, one thing we can do is we have to seriously ask whether commissions of inquiry need those coercive powers. British commissions, for instance, don't have coercive powers. They're not headed by a judge. They're not formal. They often, when you look at them, look more like a meeting in a meeting room, and they tend to be more effective. And one of the problems that we have in the Australian context is that the full-on royal commissions tend to bog down because everyone lawyers up, because it looks like a court, so everyone thinks they have to have lawyers. And there's been some very bad examples of commissions that have failed utterly because of the no one's willing to say anything, disclose anything, and everyone has lawyers as intermediaries. Extremely costly. Anyway, I don't want to spend too much time talking about inquiries. Suffice to say that most law reform commissions are set up as inquiries, but they're not set up with that judicial model. They often have a senior lawyer at their head, quite typically, but they operate much more like the British form of inquiry, where you have meeting rooms, you talk to people, you maybe call some public hearings, but you don't have that pseudo-legal process. Anyway, there's a lot more we could say about that on a different day, and I'm sure if you're studying administrative law, you'll do lots of things about these because they're very, very interesting. But today we're talking about law reform. So that's the foundations of what a law reform commission typically is. It's a standing commission. It has these powers of investigation, often doesn't use them in very coercive ways, but then reports back to government and makes recommendations for change. Now, there are 7 stages of the law reform process, which will appear on the screen here now. And I'll talk about each of these in more depth as we come to them. The important thing, again, is that these are not established under law anywhere. They're not required. They're simply good practice that's evolved over time. All right, so let's start at the beginning. The first thing that must happen, and this is mandated by law, is the terms of reference. Now, the terms of reference are set by the Attorney General, typically not as an individual, but as the representative of the government, and the terms of reference define the scope of an inquiry. For law reform, it defines the scope of what can be investigated. Now, it is possible, if you realise that partway through an investigation you need extended terms of reference, you can go back and ask for fresh terms that have those extended conditions involved. This happened several times, for instance, in the Fitzgerald Inquiry, where they started out looking into police corruption, and then as they found out there was corruption elsewhere, not only did they need extension of time, but they also needed the ability to inquire into other fields of corruption. Now, in law reform, the law reform field, you tend to operate on very tight budgets and very tight time frames, so it's important to get those terms of reference done right the first time. And it's not all that often that those terms are changed, and often they exist, they come about in a process of negotiation between the government and the commissioners and the chair of the commission, and so that they're drafted in the best possible way. So they set out the scope, they set out the time limits, and when reporting has to occur. The next stage is not such a formal stage, and that's the definition of the key stakeholders. And that's where individuals, groups, either in government, in public organisations, in corporations, interest groups, lobby groups, whatever, are identified as having an interest in the particular area of law reform. And while there is not formal contact with these people at the beginning, they tend to be identified so that when the next stage occurs, they can be informed and stay in the loop as to what goes on. Now, typically, they will know about this. You don't have to go out there and tell them and surprise them. Generally, these organisations stay aware of things, the law reform things that are happening in their field. But not all organisations are the same or equally well resourced. And it's important that that's borne in mind. And our system of government is a pluralist system of government. So we rely less on individuals having a particular say in the democratic process, but in groups that represent those individuals in the broader picture, and that's what pluralism is about. So we do rely a lot on interest groups, lobby groups, to have that sort of power, and we rely less on individuals each having to come along and have the same sort of opinion. We like to use representatives. So the next stage of the process is a more formal stage, again, and that's the creation of the issues paper. This is a research paper where the key question, the basic research of the field is laid out, and key questions are asked. And this is, I guess, what differentiates an issues paper from a general research paper, in that at the end of each section, and these are numbered throughout. There's no section. Question 4, what should we do about this? Question 5, what should we do about that? Now, those questions form an easy index for not only for the consultation process, where members of the public can say, I'm referring to issue 27 specifically, but it also becomes very important, an important organising factor throughout the rest of the reporting process. So it's very important to get those questions right in that issues paper, and not to be in the position where you feel you need to revise those questions later on. So the issues paper goes out to the public. There's a time period for consultation after which the inquiry will close, although there'll be plenty more work to do. So the next stage is public consultation, and this can be as simple as sending out the issues paper and waiting for public responses to come back. But there can be other things that occur in that time. So you can have public hearings, you can hold conferences, you can invite guests along to present at these conferences, you can have consultants brought in, you can even have travelling shows where there's things that are relevant to local communities. You can actually take the whole shebang out to rural Australia and set up some kind of hearing or conference in those localities in order to bring people into that process. So depending on the scale and the size of the budget that's involved in law reform, you can do lots of things at the consultation stage. But the general thing that's required is that an issues paper goes out and there's time for people to think about it, consult about it, form an opinion and send it back. Now, all the time that consultation is going on, the researchers are not sitting idle. They're continuing their research and they're continuing to write up the next stage, which is the options paper. An options paper is not a public document. It stays inside the commission itself, and it is built on and modified from the original issues paper. And what you get in the options paper is, under each of those questions, multiple options. And these are presented to the commissioners as different options for recommendation. So question 17, should we do this? Option A, we could do this. Option B, we could do this. Option C, we could do this. And maybe some analysis of the pros and cons of each of those things. And that provides the guidance for the commissioners, who are not as intimately acquainted with the actual terms of the issues paper as the individual researchers. It gives them guidance as to what are some of the things that the options they have to decide between. There's an interesting stage of the research, and it's interesting to see it from the inside of the organisation, because it's something that you don't get to see as an external person at all. This is a confidential internal document, but it also, I think, is something that is useful for researchers generally to think about. When you keep your options open, when you're writing a research paper and you think, well, there are 3 different opinions here, do I have to make a decision between them? Well, at some point you will, but during the course of your research you can keep your options open until that last final submission where you have to actually make a decision. And that, of course, is the next stage of the law reform process, is the final report. The commissioners rule on what they want for each of those recommendations between the options, and the researchers go away and polish off the final report and that is presented to Parliament, and that may or may not be subject to parliamentary debate, but that lists a set of recommendations for law reform. And that's where the work of the commission itself tends to end. The next final stage is the implementation stage, and this really depends on political will. It can depend on how well argued the paper, the final report is, but often it really depends on whether there is will within the legislature to actually go ahead, and who blocks that particular decision. Sometimes it gets modified quite heavily by the time the legal changes are made. Sometimes nothing happens at all, which can be a bit dispiriting for those working on the project. However, even if it's not implemented, a report from a law reform body is a strong and persuasive document. And a government that turns its back on a law reform body does so at the risk of being, working of ignoring a strong, well-argued opinion, for whatever that counts for. And I found that sometimes, even if a law reform recommendation is not picked up in a particular jurisdiction, it will often be functional. Well, it will often be picked up in another jurisdiction, or it may be picked up at a later date. So it's not the end of the world if once the report's done, nothing happens for a while. These things can accumulate. And these are research documents that can influence opinion more broadly. So they can be picked up by students and researchers in other fields as recommendations. They can be cited by judges. They can be used by other law reform bodies and so on. So they certainly are a strong, persuasive document. All right, so that's the process itself. Does it still work today? Well, curiously enough, this format was created in the pre-internet era, and it involved an awful lot of printing off documents and sending them out to people, and sending thousands and thousands of pages of documentation to public libraries where probably no one ever looked at them. It actually works extremely well, and so much better in an internet-enabled democracy. And it's a form of public engagement that I think is a very strong and important one to think about with digital democracy. It's a way in which people really can have their voice heard, can really get involved in the way that we are governed and the ways that our laws are made. Now, in the past, law academics had a very strong role in this process as well. And unfortunately, with the changes to the way that universities are funded, this has become more and more difficult for academics to do, because academics are under significant pressure to raise money for the university, and for whatever reason the government has decided that contribution to law reform is not something which is fundable as research, which is a great shame, because it's a great opportunity for universities to prove that they're relevant to the community and that they actually are involved in change. But these are things that are outside of our hands, and many law reform commissioners have lamented the fact that law academics are less and less able to engage in the reform process today. However, students are still free to engage, and I think are freer than ever. And this is where the continuing theme in this research subject that this video is part of, and throughout the way my particular approach to legal education, it's never been so important for students to be involved in law reform. One important way that you can serve your community is by engaging in law reform, possibly as an individual, but I think there's a lot of strength in working with community bodies who need to represent their position before a law reform body. So there are many issues that a great number of charities, public organisations, need to have their opinion expressed to, but they don't have the time or the resources or the expertise to have someone on staff write up their public response for them, and they often end up writing something that is not really representing their interest because they don't have any other opportunities. So it's a fantastic opportunity for law students to be proactive and approach a local organisation and say, well, there's a new review going on guardianship rights. You are an organisation that represents disabled people, and there's guardianship issues that are relevant to you that come up in this inquiry. Would you like me, and maybe my small team, to help you draft a response so you can send that off? So that's, I think, a very important form of community service that you can be involved in. And if you want to be mercenary about it, this is also a fantastic artifact for your professional portfolio. So, there's a lovely virtuous circle here. Not only are you able to serve the community, but you also then have this wonderful artifact that you can show to employers that shows not only that you have research skills, but also that you're committed to these values of community engagement and to rule of law as a broader topic. So I think what we'll that's a good point to leave it on, and to turn it back to you and to say, this is something that is important and relevant as a citizen, but it's also something to think about as a good sort of process for you to be involved in as a student. And also, don't forget, there are a whole lot of careers in the world of law reform. So not only are there the researchers who work in the law reform bodies, but there are also people employed in large organisations, in corporations and so on, to respond to these kinds of law reform activities as they occur.